Start. Para. The present complaint is being filed by 4 complainant employees for themselves and on behalf of other 68 employees, alleging unfair labor practice under items 9 and 10 of Schedule 4 of the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971 (MRTU) and PULP Act 1971 In short, it is the case of complainants that the respondent number 1 is a cooperative bank employing over 140 employees over 7 branches all over Mumbai. Respondent numbers 2 and 3 are functioning in the capacity of chairman and general manager. The Union Cooperative Bank Employees Union is representative and approved union under the provisions of the Maharashtra Industrial Relations Act 1946 in short MIR Act . It is long-standing custom, usage and practice in the respondent number 1 of paying an ex gratia amount on basic dearness allowance and VDA. Said amount is being paid annually since last several years on or before Diwali festival, and the current amount was 12.5% on basic DA and VDA. Para. Prior to 16/10/2009, no amount was ever deducted from the amount of ex gratia, and the whole and entire amount used to be given. However, for the first time on and from 16/10/2009, 5% amount from the amount of ex gratia was directly deducted and paid to the union without any information and or consent of the workmen. This fact came to the notice of employees on 16/10/2009. The respondents never even whispered about any such deduction to the concerned employees. Knowing the facts of the said deduction, the workmen contacted to the respondent numbers 2 and 3 and requested them to reveal the nature and function of said deduction. It is revealed that the said deduction was effected in order to be paid to the said union as union contribution. Therefore, complainant addressed letters dated 16/10/2009 and 7/11/2009 protesting against said arbitrary, unjust, illegal deduction. The respondents did not reply to the letter of the complainants. Therefore, the cause of deduction of amount attracts to unfair labor practices, as well as same deduction attracts illegal change as contemplated under Section 9A of the Industrial Disputes Act 1947 for short ID Act . Finally, the complainant sought appropriate relief to that effect. Para. Record shows that the respondent numbers 1 to 3 have not filed any reply or written statement, but the respondent number 4 impleaded in present complaint by order dated 29/3/2010 and filed its reply at Exhibit C3. Thereafter, the complainants not pressed interim relief application on 21/3/2014. My learned predecessor, by order dated 21/4/2014, proceeded complaint without written statement so far as stand of respondent is concerned, though not filed written statement, but to sort out the case make out by complainant, it shall be proper to rely on Exhibit C3 para. The respondent number 4 denying all the allegations submitted that the complaint is not maintainable for the reason that the respondent union, being a representative and approved union, is having exclusive right for collective bargaining so far as present complaint is concerned. The issue involved in complaint is of collective bargaining nature. Therefore, individual complainants are not having locus standi. The respondent union in its capacity has signed various settlements governing the service conditions of the employees. Benefits of such settlements are extended to all the employees, including the complainants, and they have enjoyed such benefits without any kind of restrictions or reservations. Respondent number 4 union had signed a settlement dated 12/4/2007, which was substituted by settlement dated 27/5/2010 on expiry of earlier settlement dated 12/4/2007. By virtue of clause 29 of settlement, the deduction 15% is required to be made towards union contribution from the amount of arrears arising out of said agreement from every employee to whom said agreement is applicable. Stop.